Also, this event is being recorded. So just wanted to give you an FYI on that. So without further ado, let's welcome our esteemed speakers from Hopkins and Carley's Employment and Labor Law Practice Group. We have Karen Cogbill, Sean Bothamley, Jen Coleman, and Kiara Porter. So speakers, welcome.
Thank you, Denise. Kiara, before we jump in, did you want to say something?
Sure. We just wanted to give a little information about our firm. My name is Kiara Portner, and I'm the co-chair of Hopkins and Carley's IP department. Our firm is really excited to participate as a key partner to SV Forum in the Startup and Venture Capital Club series over the next 12 months. Just a bit about our firm briefly before we get started with the presentation. We have over 70 attorneys geared towards working with startups, investors, and middle market companies through their life cycle. We provide a full service firm where we can help companies through the whole business cycle, including expertise in formation, financings, M&A, intellectual property, trademarks, privacy, licensing, employment, which you'll hear about today, real estate, and litigation. So basically all the service offerings needed by a startup. As attorneys at Hopkins and Carley's, we focus on understanding our clients' business and operations and the technology behind it to provide the most practical and effective advice. We're comprised of former big law attorneys, and we streamline staffing with more senior attorneys and partners that are at lower billing rates than many junior associates at national global law firms here in Silicon Valley. So we look forward to engaging with you over the next 12 months and hope that you enjoyed the program today. And I will let them get started. Thank you.
Excellent, thank you so much. Sean, if you want to go ahead and put our slides up. As Kiara mentioned, today's presentation is going to focus on key employment issues. So Sean, Jen, and I are all in the employment group over here at Hopkins and Carley, and we are sort of here to help along the way. So let me just give a quick reminder, if you have questions as we go throughout the presentation, just drop them into the Q&A box. To the extent that we can answer them, just with a quick short answer, we'll do that directly in the box. Otherwise, we'll talk about them in more detail as we move forward. So look, the truth is there is a ton of employment laws that startups need to know. Certainly more than we could ever potentially cover in this morning's presentation. Our goal today is essentially to give you kind of a quick list of what are the key things you want to be looking out for, more of, I would say, like an issue spotting suggestion. And then that way, once you sort of see what resonates with you, we can sort of dive deeper into it as we go. So again, present today, it'll be myself, it'll be Sean and Jen. Let's start with our very first topic or question, which is, are you, so wonderful, you've got this idea, you've got this startup. Do you have employees or do you have contractors? And how do you know when to make that distinction? So first of all, I would say, having worked with startups for a long time, I think that this is one of the biggest areas where companies can get themselves into trouble, which is there's this general notion that either everybody is an independent contractor, right? We're just sending them a 1099, they're just sort of helping us out, and we're going to classify them as a contractor, not as an employee. Well, in California, Massachusetts, and New Jersey, we have what is called the ABC test. Let me tell you, generally, as you know from maybe the Uber and Lyft litigation, right, where drivers are suggesting that they should be employees instead of independent contractors, there's a lot of litigation that surrounds this. So in California, Massachusetts, and New Jersey, where we use the ABC test, let's actually go back one more real fast, Sean. The key is that the individual must be free of control. They must perform work that is outside the usual course of your business, and then they must be sort of engaged in this independent establishment. Under federal law, there is a different test that's used, but is maybe not as rigorous. It's a little bit more generous to the contractor designation. You can go to the next one, Sean. But the point here on this is that if you have a situation, and I had a client that I was doing this with yesterday, where they said, well, we're a little short-staffed right now, so we just brought in a bunch of contractors to help us out. But the truth is the contractor is doing exactly what the employee is doing. In fact, they're working side by side. That right there is a huge red flag that you've got somebody who's misclassified. Why should you care? Okay, well, first of all, there's potential for unpaid wages, overtime, litigation. But the other piece of this is if you are in your, if you're in a situation where you're either trying to raise funding or you're going through merger and acquisition, there's going to be pretty significant due diligence that takes place. And I will tell you, one of the first things that I'm asked to do when I do due diligence is to evaluate what is the risk that they've got, that this company has people misclassified as contractors versus employees. Okay, next slide. So related to that, if you are going to make them an employee, the next question is, should they be an exempt employee, which means they're salaried, you don't have to pay overtime, or do you make them a non-exempt employee? So the default, I will tell you, is that everybody is non-exempt by default. People are non-exempt. You have to establish and prove that somebody can be exempt from overtime, right? The general rule is people should get overtime if they're working overtime. So what are the exemptions that we have? There is the executive exemption. This one is somebody who is managing like 2 or more people. The administrative exemption, think about this as somebody who runs a department, maybe your HR department, for example, or maybe payroll. They may not have direct reports, but they're independently responsible for this kind of department within the organization. You have your professional exemption. These would be your engineers. It could be your attorneys. Doctors fall under this. Think of people who are highly licensed or require a great degree of skill. And again, there's specific tests to do it. Computer professionals. These, this is not your IT help desk. This is not your sort of regular day-to-day kind of computer person. This is somebody who is really working on the development of your systems, coding, things along that nature. The computer professional exemption is actually one that is a lot harder to meet than I think people assume. You have outside sales. So if you have somebody who is spending more than 50% of their time outside of the office, engaged in sales activities, going out to customers, going door to door, whatever that may look like, that would be sort of your outside salesperson. There is also an inside sales or a commissioned exemption. This I asterisk because it is one that is very, very often misused. This is intended for somebody who earns more than 50% of their compensation by way of commissions. And then finally, not in California, but at the federal level, we do have somebody that's just a highly compensated employee. So if you pay someone just a minimum high enough salary, they can be exempt from overtime. We don't have that here in California. Next slide. So when you talk about the exemption, there's 2 pieces of the exemption. There is a duties test, and then there's a salary test. So for the duties piece of it, this individual to be exempt, right? There's, in addition to kind of meeting the general descriptions that I gave you, they must also be, have this sort of independent judgment and discretion piece where they really are working on sort of high level things, are not being micromanaged. They can really bind the company with some decisions that they're making. And the other piece of it is that this has to be their primary duty. And what we mean by that is in California, so if we look back at the executive exemption, which was the managerial one, where you're managing 2 or more people. In California, that has to be your primary duty, meaning you have to be spending more than 50% of your time actually managing those employees. If you're only managing them some of the time, and then you're doing the same thing that they're doing the rest of the time, you're not going to meet that exemption. The other piece of it is a salary piece of it. So in California, to meet the exemption, they must be paid a minimum currently of $58,240. And that is a set salary. That's not by commissions or incentive comp or things that might get them above that. That is just their base salary has to meet that amount. So the next one is the liability piece, which is the exact same things that we said on the with the respect to the independent contractor or the employee designation. We did have a question I do want to jump in here real fast, which just says, if we are not paying our people, does it matter much if they're employees or contractors? So I'm going to have to, obviously I would need to know more about this. There are very few people who can work for your company without any type of compensation, right? Exactly. So it is, if you are the founder, you obviously can work without taking a salary or a draw from the company, but that's kind of about it. I actually recently had a case where we had two co-founders. One actually only had about a 15% interest in the company. He was originally, the other individual had 85%. They had a limited amount of funds to start with. The one who had 15% was brought on sort of as the, in addition to being a co-founder, was the vice president of engineering. He was paid a salary for a while. The company ran out of funds. So he was no longer taking a salary. He continued to do work. Unfortunately, the relationship between the two fell apart. The company went under, and the individual who had the 15% interest sued the company for unpaid wages and said, I was working for these last 4 months and I wasn't getting paid anything. Labor commissioner granted him minimum wage. It doesn't matter that his title was a co-founder. The fact that his interest was only 15% of the company, the labor commissioner felt was not sufficient. He is still entitled at a minimum to get minimum wage for all time worked. So you don't have to necessarily make somebody exempt, but at a very, very bare bones minimum, you have to pay the minimum wage if they're an employee. If they're a contractor and they're a true contractor, then that's going to be by negotiation as to what they're making. But there would likely be some piece of compensation related to that. Okay, so let's go to the next question, or I'm sorry, to the next slide, John. So the next thing we're going to quickly talk about is sort of employment contracts and other written agreements. So first of all, the question is an offer letter versus a formal agreement. Okay, the default, and I'll kind of couple this with the second one, which is at-will employment. So the default is that everybody is employed at will, right? They can leave whenever they want, and you can terminate them whenever they want, provided it's not a reason that has to do with discrimination, harassment, or some type of a protected characteristic. But you can otherwise fire people at will, and they can leave at will. So what you have to decide is, are you going to bring this individual on essentially in an at-will relationship? Or are you going to have an actual term agreement whereby you say, okay, I'm going to hire you in this role. You're going to be in this role for 1 year or 2 years, whatever it might be. Here's what your compensation is going to be. Most individuals have that general offer letter where it's an at-will employment. There may be certain individuals like C-suite executives where you would bring them on in a formal agreement with a term. If you are doing the formal agreement, right, you have to look out for some things. So one is a for-cause provision, right? So if at any point the company needs to terminate this individual, we need to have very clear definitions of cause and what gives us grounds to terminate the employee. Because typically when you have a term agreement like that, if you terminate the person before the end of the term, you're going to have to pay them for the remainder of that term, right? So you have agreed to employ them for 2 years. You decide 12 months into this just isn't working. You let them go. They say, well, that's nice, but I want my paycheck for the next 12 months because you agreed to employ me for 2 years. So this is where you want to have a very good, and obviously as the company, a broad for-clause provision that gives you a lot of room to get out and not have to continue paying this person if it's not working. You also might want to think about sort of pre-employment or post-employment incentives, right? So you're going to do a sign-on bonus, or you're going to do a moving allowance. With the post-employment incentive, sometimes what we see in employment agreements for the term employment, it says, well, if we fire you, if we terminate you, we'll pay you 3 months, right? But we don't couple that with or it's not coupled, it should be coupled, it's not coupled with a release of claims, right? So if you get terminated before the expiration of your contract, and and we have an agreement where we're going to pay you 3 months or 6 months of a severance, we want to couple that with, in exchange for you signing a release of all claims you might have against the company, right? So we want to make sure that any post-employment incentives are coupled with a release of claims. Benefits. Okay, so bonuses and commissions. In California, if you have an employee who is working on commissions, you must have a written agreement that is signed by the employee, which details how the commissions are going to be earned, how they're going to be paid, and really leaves as little room for dispute as possible. I strongly encourage the same thing with respect to bonuses, right? Often we will see just this outset at the very beginning of the relationship, just this promise of, you know, I'm going to pay you a base salary of $150,000 and potential incentive compensation, you know, up to another $150,000 to be worked out between the parties. And that's like the end of it, right? And then a year later, things go south and the employee's like, I want my incentive compensation, right? I want that extra $150,000. And now there's this dispute of like, well, how is it going to be earned? You know, how do we know that the person got it? Do we need to have language that says you must remain employed by a certain date in order to be paid a bonus? So the more certainty around your bonus and commission plans, the better you are. Controlling law. If you do have an employment agreement and the person works in California, it must be governed by California law. If it is not governed by California law, you are in violation of a statute, which carries penalties, but it also could be voided. The final one is arbitration and whether or not you're going to have arbitration agreements with your employees. There are pros and cons to arbitration agreements. Arbitration agreements are fantastic to prevent class actions as your workforce grows. It also, you know, keeps things out of the public, the jury, right, the courts, things like of that nature. But arbitration is expensive. As the employer in California, for example, you have to pay the full cost of arbitration. That's the full cost of the arbitrator, and you know, which itself could probably run $30,000 to $40,000. So one question was, can you reduce an employee's salary? Can you reduce the salary to? Can I cut the salary without notice? The answer. So let me tell you, you can always prospectively change somebody's compensation, either up or down. You do, however, have to give them some notice that this is happening. I recommend, although it's not a bright line rule, a minimum of 7 days notice that there's going to be a change in their compensation, right? Because they have to decide, are they going to continue to work at this reduced salary or this reduced hourly rate? You can't decide retroactively that you're going to pay them less for the work they just performed. Okay, Sean, our next slide. So a couple other just key considerations. There was a couple other agreements which Jen is going to talk about in hers with trade secrets, kind of confidentiality piece of it. Do keep in mind that non-compete agreements are not lawful in California. They are allowed in some other states. So you do want to give to consideration as to, you know, are you perhaps overreaching with your employee? Okay, last section. John. Okay, so a few other things when you're hiring employees. You are prohibited from asking the employee what their prior salary was, right? So you cannot ask an employee to disclose in an employment application or in the hiring process, right? Well, what were you making at that last company? Because, you know, the idea is that this sort of all ties back to equal pay and trying to make sure that somebody is not historically underpaid. Because if I know that your prior company was underpaying you, I may think I can get you for a bargain and pay you less. You do have to be careful with respect to making a decision based on criminal history, and also with respect to running background checks. Background checks is, if you get to a point where you're doing a background check on a client, or I'm sorry, on an employee, please make sure that you're working with a third-party vendor, that you are, you know, having the consent forms evaluated. Sean and I have a case right now where it is a super, super technical issue, but the consent form on the background check said that the person could request a copy of the results. And that technically is not permitted within the authorization form, and that is a technical violation. And then finally, keep in mind that you cannot make decisions with respect to hiring based on anybody's need for an accommodation or anybody's race, gender, ethnicity, national origin, sexual orientation, any of those things. So I know that was a lot to throw at you. I'm going to turn it over to Sean right now. Please continue to put questions in the chat box. Like I said, if we can answer them, we will, either within the presentation or just directly into the box.
Great, thanks, Karen. So the first thing I'm going to go and touch on is leave policies, whether it be vacation, PTO, which is the same thing, sick leave, or other protected leaves. Each presents a number of trouble areas you need to be able and prepared to navigate. First up is vacation. There are a few key things to watch out for when it comes to vacation policies. First is it's a creature of contract, meaning that unless you provide for it, it's not really required. It doesn't exist unless you have a policy that says it does. However, once you provide it, you need to be consistent in how you actually provide it and how you follow that policy. Second, and this applies in California, if you provide for vacation on an accrual basis, and an example of that is, an employee gets 1 hour vacation for every 40 hours worked, those accrued vacation hours are considered wages, and all of those wages need to be paid out at the time of termination. And I'll get to that a little bit later on in this about things to consider at the time of termination. But you can't have the employee forfeit it, and you can't use it or lose it policies where if the employee doesn't actually use it, it's gone and it's taken away from them. To get around this, we're seeing employers use more and more often things called unlimited vacation policies. And when those are done right, you can avoid this accrual issue. And essentially those policies say you can take as much vacation as you want, but you just don't accrue it. But it needs to be done correctly, or else it can be interpreted as a de facto accrual policy. Let's say if you limit your unlimited vacation policy to a certain number of days per year. Next is paid sick leave. All employees in California, and now in many other states, as California set the trend for this, have guaranteed minimum sick leave based on the number of hours worked. So California has a 1:30 ratio, meaning an employee gets 1 hour of paid sick leave for every 30 hours worked at a minimum. Employers can provide better benefits than that, but that generally is the minimum restriction, and it applies to all employees in the state. If done correctly, you can actually combine your sick leave policy with your vacation policy and put it all together. But when you're dealing with people taking sick leave, you also need to be careful of local regulations. So for example, in San Francisco, they have heightened minimum amounts that are generally required for sick leave policies. In addition, especially right now, we're seeing a lot of mandatory COVID sick leave laws and regulations in effect. These happen not only at the state level, but at the local level. So another example, in San Jose, where we are, we have a COVID sick leave policy that fills the gap from where the old federal policy, the FFCRA, used to apply. That was the federal COVID leave policy or law. And so that fills in the gap. So anybody that didn't fall under that or doesn't currently fall under that now may fall under the San Jose policy. And you need to watch out for this, because when you're talking about paid sick leaves and statutes that provide for leave, that leave is generally protected. And by protected, I mean you can't discriminate or retaliate against an employee for wanting to take that leave or for actually taking that leave. We also have a lot of other protected leave laws that start to pop up as your employee count grows. Most of these are protected similar to how sick leave is protected. And some of them add an additional layer of protection in that they guarantee some level of reinstatement when the employee returns back to work. For example, if they took a long leave of absence for a family medical issue and they're coming back, you may have to accommodate them by reinstating them to a position that's open, even if it's not their earlier position. And as you can see on this slide, I've got a lot of examples of California laws that pop up, with 5 or more employees, 1 or more employee, 15 or more employees, 25 or more. These show just the number of different areas that they extend into and the types of leaves that can be protected that you might not think of. And we also have federal acts that stretch across all states, which are also applying at the same time as, if you're in California, all of these other laws. For example, Title VII that talks about anti-harassment, discrimination, retaliation, FMLA, which is the Family Medical Leave Act, and we have acts like the Americans with Disabilities Act and the Age Discrimination in Employment Act. All of these are interplaying at the same time, and they tend to trigger based on the number of employees you have. On this slide, I have even more examples of some other leave laws that can apply. And the important thing to remember for all of these is that as your business grows, you begin to take on greater responsibility for ensuring that your employees are accommodated and protected for their leave, because your business is going to be judged as being able to bear more responsibility on that end. And as you grow, you need to be careful about meeting these obligations, because with the protection that these employees get, oftentimes these laws allow for employees to sue their employers when these laws are violated. And when you don't give the protected leave, or you retaliate, or you discriminate against them by passing them over for a promotion or not giving them a later benefit. And litigation is often the most expensive aspect of all of these laws, beyond just providing the leave that it's providing for. The next topic I'm going to address primarily concerns, again, California law, and specifically California labor code sections that commonly trip up employers and that we see most frequently in litigation. And the first one I'm going to touch on, we see a lot both in single plaintiffs cases and class actions, and it concerns wage statements, or another term you might use for that is pay stubs, the thing that's attached to the paycheck, which breaks out a lot of information about what the employee is getting. So California generally requires 9 unique pieces of information on every employee's wage statement. That's gross wages earned, so hours worked times their hourly rates, the net wages earned, which is all the wages they get after all the deductions, all of the deductions that are being made and the amount of that, the total hours worked by the employee, any sort of hourly rates that apply for each of those different hours, whether it be regular, overtime, double time, premium pay for weekend work, what have it. The number of piece rates, if you do piece rate, although that's pretty uncommon, the dates of the pay period that it concerns. So if it's biweekly, the start of the first week and the end of the second week, the name of the employee and 4 digits, either of the last 4 digits of their social security number or some identification number. And the one that we see, I think, most often tripping up employers on a mass level is the correct name and address of the legal entity that is the employer. And all of this might seem really simple, and most employers don't give it a second thought once they've hired a payroll company. But I will bet you that no matter what payroll company you choose, if there's a mistake on one of these wage statements, they're not going to take any responsibility. And somewhere in that contract that you sign with them, you've taken on all obligations of making sure the information is accurate. And their position is probably going to be, we only provide a service that allows you to provide accurate statements. We're not guaranteeing that they're accurate. And we see this time and time again, where the name of the company isn't actually the full name of the company, and an employer gets dinged with penalties. And this relates to the importance of registering your businesses and making sure that whatever you're registering with the Secretary of State's office, whether in California or elsewhere, is matching what's on your wage statement. Or if you're using a DBA, that the DBA that you're putting on your wage statement is okay, because sometimes it might not be. And that if you are using a DBA, you've actually got it registered somewhere, and you're not just using it without having registered it in the counties or the state where you're working. And the consequences of non-compliance are generally mandatory penalties, which are almost impossible to get out of. And it also gives rise to potential lawsuits called PAGA claims, which we see a lot. Basically, It's an employee that steps in the shoes of the state of California and goes after civil penalties against you. And those civil penalties for incorrect wage statements can rise to $1,000 a pop for every violation per employee. So these numbers really inflate at some point. So it's important to make these small changes to make sure that these things are accurate. Another area and another issue we see in California under the labor code, which is a frequent focus of class actions, concerns business expense reimbursements. So on this slide, I've got the language of the statute, which is Labor Code Section 2802. Basically, an employer is obligated to reimburse and indemnify their employees for any necessary business expenses or losses that they incur either in the discharge of their duties, which is them performing their job, or in their obedience of the directions of the employer. Now, the most common business expenses we've historically seen and dealt with mostly relate to travel. And those are the really easy ones to spot. Plane tickets, taxi fares and Uber rides when you've sent your employee somewhere, mileage, if you're having your employee drive their own personal vehicle on company time, on company business, aside from commuting to and from work. Those are all generally reimbursable expenses if it's done in the performance of their duties. And for mileage, California generally accepts the IRS reimbursement rate, and it comes out to about 51 cents per mile. So if you've got employees that are traveling a lot, that can add up. It's half a buck for every mile that they drive. And those fluctuate every year. So you need to be sure you're matching it correctly. There are other options for reimbursing that expense, but it all comes down to whether or not you're actually reimbursing the employee fully for their use of their vehicle or for the travel. The less common, but I think more increasing in relevance, certainly at this time with the COVID pandemic and work from home, are things like phone and internet use, which potentially can extend to things like if you require your employees to use an app to track their time on their phone, or if you are expecting your employee or you need your employee to use their home internet in order to perform their work while they're working from home. And ergonomic accommodations, so standing desks, ergonomically designed chairs, keypad rests, those small things all potentially start to involve Section 2802 and might need to be reimbursable. And they're often hidden costs and expenses. So you need to watch out for that and make sure that if you actually are requiring employees to do things at home away from the office, they can still be covered by this. And if you're doing it for a lot of employees over a long amount of time, you're looking at a potential class action lawsuit, which can get pretty expensive. The last issue I'm going to touch on is going to be involving basically the end of employment. And Karen talked about this a little bit already, but I'm going to get into some specific labor code requirements in California. And that concerns the need to pay final wages at the time of employment termination. So if you terminate an employee or an employee resigns, either with notice or you had an idea that the termination was coming, all of their wages, including accrued vacation, need to be paid out at their last day of work. If you terminate an employee suddenly, such as on the spot because of misconduct, or if they quit without notice, you're generally given up to 72 hours to pay those final wages. Although sometimes you don't actually have 72 hours, it's less. So you need to be careful about the circumstances of how that employment ended. But overall, you need to be able to pay and have those wages ready for payment at the end of the employment. And it's one of the easiest rules to mess up because you don't have to do anything to mess it up. All you need to do is issue a late check or wait till the end of payroll to issue the check. You actually need to do it before payroll runs if it's at the start of the week or the start of the semi or biweekly pay period. And it also comes with one of the most severe penalties, which is every day that that employee waits, they get a day's wage up to 30 days. And even under minimum wages, that's thousands of dollars in penalties that that employee can potentially accrue. So it's important to make sure that these employees are getting their pay on their last day of work. And then again, what Karen was saying earlier, another thing you need to consider is severance. So severance alone isn't going to help you reduce any risk for the company. If done right, severance combined with a release of claims can help you close out a lot of potential liability that might arise from former employees that either resigned or that you fired or terminated or that were laid off. But it's not as easy as slapping a release of claims onto a severance agreement. There are a lot of ways that you can accidentally void that release. For example, if you have employees that are over 40, if it's just one employee, you need to have a mandatory review and revocation period for them to consider that release and decide whether or not they want to sign it and stay signed. If you're dealing with employees, several employees over 40, then you might be triggering what's called the OWBPA, which is the Older Workers Benefit Protection Act, which provides even longer review and revocation periods. And then similar to what we talked about with the final wages, you can't have your severance be the employee's final wages. You need to have the severance be something in addition to what the employees already owed. Because if you don't pay out all undisputably owed wages, any release you attach to it is going to be void and unenforceable. And now, again, I know that's a lot, and we're saying that at the end of each section, but this is basically to give you the idea of watch out for these important labor code sections and these requirements, because they are easy pitfalls, traps to fall into when it comes to wages and reimbursements. And now I'm going to pass it off to Jen, who's going to talk to you about some important IP issues.
Hi, everyone. My name is Jen Coleman, and I work with Sean and Karen in the Employment and Labor Practice Group at Hopkins and Carley. And I also work with Kiara on the Intellectual Property Group. So I'm here to talk about trade secret issues in the context of employee mobility. So let's start with the basics. What is a trade secret? Much like Sean's presentation, I'm focusing on California law. So you need to figure out what jurisdiction you're in. Federal court is the DTSA, the Defend Trade Secrets Act. And then every state has a Uniform Trade Secret Act. So I'll be focusing on California's Uniform Trade Secret Act, which is called the CUTSA. So there are 3 requirements to have a trade secret in California. 1, the information you have must be secret. 2, the information has to have actual or potential commercial value because it's secret. And the owner must have made reasonable efforts to keep the information secret. Now, if you notice, the word secret is in every prong of these elements. Okay, next slide. And it makes sense if you think about it. I mean, if you take the phrase trade secret, the elements fit right in. So it's really intuitive. It provides you a competitive advantage, you have the potential to make money, and it's kept confidential. Usually during this part of the presentation, I'm in front of a group of people, and I ask people to raise their hands to tell me how many people have trade secrets in their company. And everybody raises their hand. And then the next question I ask is, well, can you tell me what they are? And about 25% of people raise their hand. And so that's a problem. You notice the word secret was in every prong of that definition of what a trade secret is. But if you don't know what your trade secrets are, you can't train your employees on what your trade secrets are. And you also can't train them on how to use or disseminate those trade secrets, or how they're supposed to hold them private to third parties, customers, internally or externally. So this is why training and your culture at your company become really important. So first, you need to build a culture of respect for intellectual property rights. And that sounds intuitive, but it's really not. Everyone is always looking for a competitive advantage, especially in Silicon Valley. So you really need to build a culture of respect for not only your intellectual property rights, but also other companies. Initial and periodic training is also very, very important. We didn't have a chance to talk about handbooks today because we had a limited amount of time, but generally companies have employee handbooks that have policies and procedures in them. And some of those policies and procedures can include things like training, what is company property, codes of conduct, those types of things that you really need to identify so employees can understand what their obligations are. with respect to the company's property and what the company's property is. I was in a deposition once on a trade secret case, and we put an agreement in front of the employee, and the employee said, well, yeah, I signed it. And there's a definition of proprietary information in there. And I said, well, here's the definition of proprietary information. And literally it was 157 words long. And he's like, I don't know what our trade secrets are. No one ever told me. And that's a problem if you get sued. That's a real problem. So, you know, you really have to understand your business, your products, and your technology. And all of these policies and procedures, and later on when we talk about intake and exit interviews, everything needs to be wrapped up based on what your company needs. There's nothing worse than pulling a form off the internet and trying to use it, no matter what jurisdiction you're in, because it will never be specific to your company. And if it's not specific to your company or your products, likely it's not going to be very enforceable. Now, internal messaging is interesting. It kind of, you're like, well, that's the same as the first bullet point. But internal messaging is more for management. Management has to live it and enforce it and believe in it. And if management doesn't do that, the employees aren't going to follow either. So there's nothing worse than getting in a situation where you have all these great policies and procedures about what people are supposed to do, and management ignores them, which means the employees ignore them. And that's almost worse than not having a policy at all. Okay. So policies and procedures that you implement with respect to your intellectual property in general, whether it's trade secrets, patents, copyrights, or trademarks, it really is going to depend on your IP portfolio. And if you're focused on trade secrets, like a lot of people in the Valley are, that and patents really mostly, you know, you want to focus on how your employees can use your trade secrets, how they can disseminate them and disclose them, and what reasonable efforts they need to take to make sure they stay secret. And the reasonable efforts that a company has to expend really depends on the size and sophistication of your business, and it changes based on your technology and your business products. Some things to consider, information security, and I'm just going to run through a few of these at a high level. You have to protect your information. So, you know, do you have dual authentication? Do you have encryption? Do you have software in place that allows you to pick and choose who has access to particular databases? You really need to make sure that the people that have access to your trade secrets really need access to them for them to be able to do their job. Email and internet usage. I'm going to go back to policies and procedures again. You know, one of the things you really should do is make sure when you're talking about email, internet usage, company property, anything like that, you need to make sure that your employees know they have no expectation of privacy. So in the event that you need to get into an email, get into some kind of account to see if any of your trade secrets are being disseminated that were not authorized, you have to have that ability, but you really need to make sure your employees understand that. The devices and equipment I'm going to touch on because Sean briefly touched on expenses. BYOD means bring your own device. So there are companies that allow you to bring your own cell phone to do your work as opposed to providing it for you. Just keep in mind that might also trigger the company's obligation to pay some type of expense reimbursement for that phone. I'm going to skip down to records management and classification software systems. You see a lot of this in tech where you have engineers that have to work on particular projects, but not all engineers have to work on particular projects. So if you only have 6 folks who really need access to particular information, then limit access to those 6 folks or make it based on a supervisor's written authorizations. You really want to make sure you try to protect your information and classify your data in the appropriate way, which again goes back to know your business, know your products, and know your technology. Okay, Sean. So now we're going to talk about some best practices on onboarding when you're dealing with trade secrets and company information specifically. So we'll talk about a lot of these different types of agreements in later slides, but I want to focus on non-disclosure for right now. Non-disclosure agreements are really important. You can have them pre-employment and you can have all your employees sign them, But at the same time, you really do need to make sure if your employee is going to sign a document like this, make sure they have access to confidential and proprietary information. You may not want to go from C-suite executives all the way down to cleaning staff if you have 750 employees in your company. So, just modulate and figure out who actually needs these particular agreements. And if you don't know, err on the side of caution, but still try to make it tie into your business needs. The non-disclosure agreement also really needs to spell out who owns what property when, and what happens upon termination of the agreement and where the property goes. So a lot of times you have companies partnering with each other to develop a product, and there are non-disclosure agreements across the board with all of their employees. Well, at the end of the day, if you don't say when this agreement's done, I own this property, you could potentially get into a lawsuit if the property that we're talking about turns out to be valuable. Non-competes and non-solicitation, just quickly before we get to that particular slide, it's jurisdictionally specific. Karen's correct. In California, they're generally void unless they're tied to the use of trade secrets and some other exceptions, but know what jurisdiction you're in. It's also not for all employees either, just like the non-disclosure agreement. You kind of have to figure out who's going to fall into this category. And you also have to figure out, based on the jurisdiction, what the scope and reach could be. Sean? Thanks. So I love checklists. They are one of my favorite things ever because it makes sure that you don't forget something. In most of the remediation cases that I have, and for those of you that don't know, remediation happens when an employee has information from a previous employer they either didn't know they had or they intentionally took, and then you have to take steps to remove that information from the employee so they can't use it. An onboarding checklist is extremely helpful at the very beginning of employment to determine whether or not an employee may have information that belong to their previous employer. Now, this is most helpful in cases when you have an employee that's coming from a competitor, right? So what this does is it walks you through the agreements that they signed with their prior employer, what happened during their exit interviews, what company property they turned over, what kind of actions the prior company took to make sure that the employee no longer had access to confidential and proprietary information. So these are very helpful, especially when at the end of the day, and in a few slides we'll get to this, you get a letter saying the person that just came to you took all of our stuff and we're going to sue you. So if you have this and you go through all of these questions with the employee, you'll have a pretty good knowledge base about whether or not they have information that could potentially get your company in trouble. The only thing I will say as a caution is that is really tied to electronically stored information. So if you don't have the ability, or your HR folks don't have the ability to really talk to someone in depth about data sources and where data is stored and where it can be backed up, you might want to consult outside counsel with respect to that. And again, that is a belt and suspenders. But if someone's coming from a competitor, especially in Silicon Valley, it's very helpful. I've had at least 7 cases over the past 2 months where I've had to do that, and had an onboarding interview like the one we're discussing now been completed, it would have caught a lot of things earlier and things could have been dealt with a little differently. So it's very important. The next agreement I will talk about, and I'm sorry I'm talking so fast, but I'm looking at the time and I know I have like 12 slides left. So some of these are going to be at a very high level. The confidential proprietary information and invention assignment agreement, the elements are there. This really is to figure out whose IP is whose. If you have IP when you join a company, you're going to have to list it out. And in California, there's a labor code section, section 2870, that has language you specifically have to include on that agreement. So just take note of that. And I think another state has that as well. It might be Georgia, I think. So just make sure that you are compliant with those types of things. And again, the non-solicitation, non-compete, we talked about a little earlier, that's for California Business and Professions Code 16600, which basically says you can't prohibit someone from engaging in a lawful profession, trade, or business of any kind. And if you do, it's void. Like I said, one of the exceptions to that, you can't use a company's confidential and proprietary information to do it. It's not called a trade secret exception, but you owe a duty of loyalty to your prior company. So just keep that in mind. Okay, Sean. And this is just what it kind of looks like. And again, this is just where you start. The definition of proprietary information should change in any agreement you have based on your business, your products, or your technology, because what we're seeing more and more now is the very general, vague definition that includes everything isn't going to be as defensible as one where you can actually identify specifically what your confidential and proprietary information is. Okay, so these are my favorite letters to get. What happens when an employee leaves the company and they go to a competitor is the competitor freaks out, especially if they are a high-level engineer or executive that had access to a lot of the company's confidential and proprietary information. So what they do is they send a letter out to the employee and copy the new employer and say, hey, just checking in. We just want to remind you that when you were employed with us, you signed all these agreements that said you would not steal our stuff. And we just want to make sure you understand that obligation. And oh, by the way, here's a certification. Please sign it and send it back. It's interesting because I also ask people if they have received these types of letters, and about half of them raise their hand. And then I say, well, what do you do? And all of them say nothing or throw it in the trash. And that is not what you should do in this circumstance. So this letter will be in one of two forms. It'll say, we're reminding you of your obligation, or we looked at your stuff and we know you stole things. So those are the two letters you're going to get. And if an employer or an employee, I'm sorry, brings this to you and says, I got this from my former employer, or you were copied on it, now you're kind of like, okay, where do you go from here? So the first thing you have to do is you need to investigate. And this is where that onboarding checklist comes in, because if you have your onboarding checklist, you've already gone through all of the devices that the person has, where the information could be stored, what happened during their exit interview, how many people, or I'm sorry, what property was turned over. Like, you should have answers to those questions. So you can go back to your onboarding checklist and you can review that and then talk to the employee about follow-up questions, because this is where you have a chance to get ahead of it. Trade secret litigation is enormously expensive. It is the divorce law of IP. So you really need to get ahead of this, and hopefully you find out nothing happened. But unfortunately, people inadvertently take things all the time and they don't know it. And I've done several of these onboarding interviews in the cases that I was just working on from the remediation perspective. And you ask someone, well, did they provide your phone? Yes. Did you have to give it back when you left? No. Are there business contacts from your prior employer on your phone? Yes. Were you ever in meetings? Yes. Did you ever take pictures of whiteboards? Yes. Did you ever back up your phone? Yes. Okay, so now I've identified 3 places where that prior company's data lives with that current employee: on their cell phone, on their laptop, and in the cloud. So now that you've figured out, okay, he really did have things, now what do we do? So now we go to remediation. And what remediation is, we work with a forensic consultant that basically removes that data so the employee can't access it. And hopefully, fingers crossed, that employee did not back up their phone on your network through their work laptop, because that'll be a little more expensive, but you can still get out ahead of it, as opposed to if you ignore the letter, you get sued for trade secret misappropriation. And by then, that employee is definitely backed up his phone to his laptop, which is now on your server, which people might be able to access. And if they're a direct competitor, that's a real problem. Okay, next slide. Okay, former employees. So I have 3 minutes, so this is going to be really fast. Exit interviews are extremely important. I have worked with 5 companies over the past 7 months that stopped doing them because of the pandemic, because they couldn't get in a room with someone to have them sign all their documents. They either did nothing, or they sent a FedEx box so they could send back all of their company property, or they just sent them documents on DocuSign to sign. You really do need to sit down and go through the exit interview documents, even if you do it on Zoom, because the one document the employee will not sign in that package is, I confirm I returned all of the company's property back to the company. So just make sure when you get documents back, if you're doing the exit interview on Zoom, or if you're doing it over the phone, take notes, make sure you identify all information they could potentially have, and make sure you get it back. And that's why a termination checklist is really good to have. Now, the NDA and confidentiality reminder certification, I'm not a fan of these, but some companies do them. My view of the world is, if they've already signed it, don't ask them to sign something confirming they've signed it, because then if they don't sign it, where does that leave you, right? So I'm not a huge fan of those, but some companies like them. You got to make sure that they return all the company property. Now, in today's day and age, when everyone's working from home, that's more than a laptop and a printer and a company, credit card and access key. Now we're talking about documents that were printed out, documents that were saved to external drives, documents that were saved locally on a desktop. I mean, we're talking about a lot of things, and that's not even going into any kind of social media work chat platforms. So just make sure that you get all your property back and you find out what they have. Separation agreement, Karen talked about a little bit, so I'm not going to cover that. The letter to the former employee and new employer we just talked about, but this is the flip version. This is if your folks leave and then they go somewhere else. I'm not a huge fan of these unless you really have a suspicion that someone took something. These are nuisance letters that cost money because people should be investigating them. And if you do believe that they took something, you should get counsel involved to make sure that you don't inadvertently recycle and wipe their laptops and recirculate them back out into the company, or wipe their phones if they turn them back in. If you think they did something wrong, you really do need to keep all of that stuff and then bring in counsel so they can identify whether or not a letter like that needs to be sent. And this is just a brief description of that type of letter. The only difference between this and the other one is this letter, the specific language will be based on the document you sign when you begin your employment. And then follow through. Just make sure you do your employee training early and often. If you suspect misappropriation, investigate it. There are 3 ways that can happen. We talked about the letter. We talked about the employee inadvertently bringing information in. The one we did not talk about is a company employee that comes to you and says, Joe Smith was hired 1 month ago. I gave him a project that should take him 3 months and it took him 2 weeks. I think he has something he shouldn't have. Then you have to do the same type of investigation. If you investigate and you find they've done something that violates your policies and procedures, you have to discipline them. Not disciplining them is worse than not having any policy at all. And the discipline has to relate to the egregiousness of the act. So it can be as simple as additional training, or taking someone off a project, or suspension or termination if it's really egregious. And if someone has done something or brought some information into the company that you now know about, you do need to remediate it and make sure no one has access to it anymore. And that is it.
Excellent. So Jen, I'm going to give you a second. We did get 2 questions that are related to your topic in the Q&A box. Well, you look at those, and there was 2 other questions. One just related generally on the timing of wages. I will say in California, you can pay weekly, biweekly, or monthly. There are some rules around, kind of those things, but you can potentially pay weekly, biweekly, or even monthly for certain employees. So Denise, I know it looks like you have something to say, but Jen, if you are able to answer those questions, we could do those real fast before we jump off.
Right. One of the questions is, how do you cover yourself in an NDA if during a conversation, the NDA receiver shares some ideas which can be used in the business? Can a small invention assignment clause be added to the NDA? So generally what the NDA does is, one of the things you need to include in there is who owns what property, right? So you're going to figure out what you're going to develop together and what you're each bringing to the table. And you will, that language will should already be in the NDA. So you can, I don't know if I would call it a small invention assignment clause, but what I would say is you can talk about the information that you share together to develop the business and determine who's going to own it. And when that's agreed on, then you can write that in the NDA. So you can do anything you want with the NDA with respect to intellectual property ownership rights, as long as both people have a say and they both sign it. So I think that answers your question. You just have to identify if you have specific ideas to your business, you're going to keep them. Or if they're giving you ideas relating to your business and that's what you're negotiating for, then they're still yours. So you just have to spell that out in the NDA specifically. And then the next question is, can you give an example of specifying a trade secret? So courts still don't even know how to do this. But what I will say is, if you're talking about identifying them in an agreement and you know what your business, your products, and your technology are, you have to look at those things and you have to decide what has independent economic value because it's secret, right? So if you have financial projections, I hate using financials and customer lists because there are ways they are trade secrets and there are ways they aren't. But if you believe that you have some kind of compilation of financial information that gives you a competitive advantage, then you can identify that as proprietary information. So it really does link back to your business and what gives your business value and why that is valuable because it's not known. So for example, if a competitor knew that information, they would get an edge in the market. So that's how you kind of go about trying to figure out what information you have that you need to protect.
Excellent. I know there was a question about the presentation deck. I think we can, I don't think it's been provided yet, but we could certainly, make that available. And I think Denise had mentioned at the beginning that this presentation was recorded as well.
That's correct. And we will be sending a link to all the attendees in our follow-up email.
Excellent. And yeah, so I guess I will just say in closing, thank you all for being here this morning. We appreciate the opportunity to speak with you. If we can be of further assistance, do not hesitate to reach out to us. We also do additional, more in-depth webinars and presentations, and we actually have one coming up next week. So if you are interested in any of those, feel free to ping us, and we'd be happy to help you.
Thank you so much, Karen, Jen, Sean. That was an amazing presentation. I know there was a lot of information in that, so we appreciate that. And to all of our attendees, just want to let you know that our next event in this series, the Startup and Venture Capital Club, is on February 25th, and we will be discussing how to achieve product market fit. So we hope you can join us then. So everyone have a great day, and thank you so much for joining us.
Thanks, everyone.
Okay, thanks, everyone.